So the question is, what's the difference between keylogger, screen capture, and someone just grabbing a camera and taking an analog picture of, or digital picture of whatever's coming off the screen?
You should be a defense attorney.
Through a window.
Oh. Yeah, but which way does that? Oh, that would be the defense's argument in this case. Yeah, that would be the defense's argument. I mean, it's as we work through this case, and it's strange because these are all made-up facts, but they always like become interesting. We have legal fights about this when we're putting the case together. It's weird, right? Congress had this law that's supposed to be about online wiretapping, but it really fits very poorly with TCP/IP and the way this all works, right?
Right.
With the phones, it all made sense. Phone, wire. Right?
Well,
Things are a lot more
and it does, and because it's more obvious that a phone affects interstate commerce, and there's also legislative history to show that that's clearly what they were meaning with it. I mean, it would be a harder argument to say that the camera is capturing a communication that affects interstate commerce.
Why not? Why would it be any harder? I don't think it'd be any harder. I think it's the same argument.
It's the receiver of the phone.
So I prosecuted a case that involved a guy, same statute, but it's traditional voice, a guy with his speakerphone on who was scribbling down notes, who was tape recording using a regular over-the-air tape recorder, and we said, oh, look, there's like 3 different interceptions happening. But we had a lot of fights over this, right? But the fact that it was jumping over this air gap didn't make it less of an interception as far as I was concerned. It was hard, though. We really had to struggle with that.
Although that's a wired communication definition.
I know, you're right.
It
doesn't have the interstate system. Good point. Good point. It's a good point. It doesn't have that definition. Yeah, I mean, one thing that's clear that I should have made clear in that answer is this is the exact same statute. So the wiretap, thou shalt not hook alligator clips to a phone line was amended in 1986 to include network interception, although there are different definitions. And the one we're fighting over right now with interstate is only about the electronic side of things, not the wire side of things. You want to just call on people? Why don't you be there?
Yeah, go ahead.
Yeah, I have a question in number 2. Why wasn't the argument that there was some sort of knowledge or consent to be recorded already present because of my TwitFace's security policies?
Yeah, these are all good questions.
Well,
the question is about consent in terms of service. You want to go ahead?
Oh well. For what it's worth, we're considering, it was getting somewhat complicated as it was, so we didn't include this, but one of the things we were considering to make it a little bit more interesting was to have an argument about some statements that the CEO would make about how his life is an open book and he's all about openness and transparency, and say, okay, well then you had opened this up. But we ended up not doing the raw question of whether there was an interception, and we had him confess to that and such. The getting onto the computer, getting inside their firewall by accessing Brutish's computer with the Snuffleupagus password, you couldn't make a particularly good argument that was a access with authorization.
And I mean, the other thing I would say, I mean, there's a lot of interesting legal issues here, but this really, if we introduce that fact, if we said that the CEO signed a policy that said, I have no privacy on this laptop, the government, I think, would still try valiantly to argue, that's consent in terms of this one party, Maria Batali and the security staff. This guy, happens to be using the very same tools, but he's not the guy I consented to. And this isn't the circumstances I consented to. Actually, as I say it out loud, it's not a bad argument at all.
No, it's
I think it might be a winner.
Argument.
It's probably a winner, yeah.
I mean, the policy would say, you recognize and consent to my TwitFace's monitoring of my TwitFace computers. So I don't think that would be a very good argument to say that by agreeing to that, you've allowed this non-my TwitFace person to come in and do the same thing. That could come up if the government did it, because and the analysis turns into a constitutional question, a Fourth Amendment question of whether you had a reasonable expectation of privacy that you gave away when you signed that agreement. Because the government's position is essentially that expectation of privacy is an on-off switch, and if you have given up an expectation of privacy as to one party, then you don't have an expectation of privacy in that information at all. But
And that was the case. The Supreme Court just decided not to address that issue. And this was I'm sure some of you followed the SWAT team member who was given the text pager and then used it to trade messages with his wife and with the woman he's having an affair with. And this was also the oral argument where Chief Justice Roberts said, now how does a pager work? What happens if someone's using their phone when you need to send them a page? And Justice Kennedy helpfully chimed in and said, I think you get a busy signal at that point. So it made you wonder about whether the Supreme Court was ready to decide this. But Kevin's right. Under the Fourth Amendment, it's absolutely give an inch, take a mile. You can't consent to lots and lots of... If you give your trash to your trash man, then you're also giving it to the rest of the world. I mean, that's just the way the Fourth Amendment works. Very, very different analysis than the one we did here.
I think we got about 10 minutes with other questions.
Weasel actually had a question.
Oh, sorry, okay.
Yeah, I had one real quick question. During the prosecution's closing arguments, the statement was made that the jury would have to go away to interpret the law. I was under the impression that it was the judge's job to interpret the law and the jury was supposed to interpret the facts.
Oh, yeah, no, that's complete. You have it backwards. No, you're right. You're exactly right. One thing we manufactured in this case is this interstate question was really a very legal question, and legal questions usually don't go all the way to the jury.
Right.
And so we were faking that because we wanted you guys to think about interstate. That the jury probably would never be left with that ultimate question. They might be left with some of the surrounding questions. Where did the interception take place? Where in respect to the network interface was it? But they definitely wouldn't get the ultimate legal question. So that was a very perceptive catch.
Go ahead.
Does the communication in question actually have to cross state lines, or does it just have to go over a system that crosses?
So only the
The
system.
latter.
Yep. And the cases are actually specific on that. It says it does not have to have left the state.
Yeah.
And just because the law professor in me wants to make this all about everything that you're reading about in the newspapers, the reason we have interstate commerce requirements like that is because courts have said that's the only thing Congress can do. That's what distinguishes the feds from state legislatures. So Congress always has to make sure that there's an interstate component, but they can stretch it really far. And this has been ripped from the headlines because in all of the healthcare lawsuits, where the state attorney generals are arguing that Obama's healthcare plan is unconstitutional, this is their argument. You're talking about something that's all within one state, and you're forcing people to do something, and this isn't the role of Congress. They're going to lose really badly, but this is very similar to the argument they're making. So.
Okay. Yep.
I was wondering, why does it matter that, why would you not argue that because the screenshot was later sent across the internet, that it was not, how is that distinct from?
I think the argument there would be that there was no interception. So to intercept, and I was sort of trying to get at this in my motion. Under federal law, if you're a party to the communication, you can't intercept it because consent of a party makes it okay. And so the communication of the exploit sending the screen grab to him, he was a party to that communication, and that communication is a separate communication from the communications that Zuckerson was having with his friend in Alaska via IM.
So, I mean, is there a reason that you couldn't hook up, for a phone conversation, for example, hook something up to record that in place and then transmit it afterwards, and that's not an interception because it was sent after the fact and that was a voluntary communication, or like he was a party to that communication?
If you're a party to the phone call in the first place, you can record it under federal law, but not under most.
Yeah, but his point is if he was a party for this is why I asked you this question. Does your argument turn on him being a party? And you correctly answered no. Because if you'd said yes, I would have done what he did and says, well, then why does the oral have to do with any of this?
I mean, I should have been clearer because the point that I was sort of getting at there was that, yes, there was an electronic communication here that went to him, which was, the video screen capture being sent to him, but that's okay because he was a party. But the other communication that they're claiming was intercepted, which was the communications at the party that were captured, well, it was just silent video, and the statute doesn't cover that. And so that's what I was trying to get at.
Here.
I guess I had a question about the definition of the system. I think you brought one case law that said, define the system very narrowly, and then I don't know how this proceeding, when you said it wouldn't go to the jury,
So you're absolutely right. That would be a judge question. And one of the things that actually Paul was pointing out was that was a particular court, the Central District of California, and that means it's not binding on other courts. Even judges in the Central District they might tend not to, but they could disagree with it. So for California, the next level up is the Ninth Circuit, which is also for Nevada and Arizona and Hawaii and Alaska and several other western states. And so Ninth Circuit decisions are binding on district courts. Ninth Circuit is binding on all the district courts within its jurisdiction. And there are other circuits depending on where you are. And then the Supreme Court is binding on all of them.
Would it be a fool's errand to argue, for example, if one captured a VoIP call, that there's no auditory component because it doesn't become auditory until the data is processed through a codec that understands the data should be processed into sound?
We've heard this argument with encryption before. So the question was, is this too clever to say VoIP calls are not voice calls because they have to be post-processed in some way before they become voice? That seems like I think most judges, even not knowing a lot about computers, are going to be really suspicious about an argument like that, right?
I think the judges would do a force for them.
Yeah, with SS7 and with current digital telephony, that you would if I were the one arguing against it, I'd say, Your Honor, they're just trying to use some accident of technology to rewrite the entire statute, right? But with crypto, it's harder. I've heard people make the argument that, and there's one definition we didn't fight over here. In order to be a criminal under the statute, you have to obtain the substance, meaning, let me finish, or purport of a communication. And I've heard some people argue that with crypto, I don't know, maybe I don't have the substance, meaning, or purport yet, right? Maybe.
Someone was arguing.
Oh, I thought it was Kevin. Someone with a feed that sounds just like Kevin. That's a pretty good. So anyway, so that's the but I think most of us up here probably think that's kind of a crazy argument.
I don't think it's crazy.
Oh, you don't?
It is a colorable argument, as lawyers like to say, and if I were a defense attorney, I would certainly make it. I don't think there's any clear law on it. I think it's I don't think it's the best argument ever, but it is. I'll just say, in another context, when I was thinking about this and was thinking about VoIP as a wire communication, I did stop myself and go, wait a second. There really isn't any case law on this, and one could, so I've had the same thought, which makes it colorable.
Yeah,
it has 2 gigs.
So it's a sign of how complicated this statute, which is called the Wiretap Act or Title III, is, that in your answer, I think I spotted 7 legal issues and probably 14 cases.